make no apologies for the fact, and I'll be upfront about the fact that we've got a little bit of a mixed bag for you this afternoon. Mike and I are going to be talking partly about the facts of the Lakanal House fire and some of the lessons learned from it and their broader relevance for regulatory law and health and safety, in particular fire safety. We're also going to be talking about the recent changes to inquest law, particularly inquest procedure, as a result of the new rules and sections of the Act that came into force in July. And the way it's going to break down is as follows. I will kick off with a quick run through some of the facts from the Lakanal House fire. I'll then talk about the recent changes to inquest law and procedure. I will touch upon some themes in decisions in inquest law and whether they might be done differently under the new rules as to how they were done in the Lakanal House fire and in another inquest. And then I'll hand over to Mike, who will talk about lessons learned from the Lakanal House fire. So firstly, a quick run through some facts from the fire itself. I imagine that some of them will be familiar to some of you, but I suspect that most of you will not have had the benefit of looking at the visual aids and images that were used in court and available in the jury bundle. So I'm going to quickly trot through an outline of the key facts using those visual aids. So firstly, this is the west elevation of Lakanal House viewed from the exterior. Imagine yourself, if you will, as a London Fire Brigade incident commander. You're looking at a building like that, you can see a fire, you don't know any of the flat numbers. Now, if I move you on to this graphic, you can see that the fire started in flat 65 on the 9th floor, and that information was known to the fire brigade as a result of a 999 call. The occupant of that flat called 999 promptly. She left the flat, and in the ordinary course of events, what you would expect is that that fire would be extinguished before it spread elsewhere in the building, and there would therefore be no loss of life. Now, a number of witnesses at the inquest said that if they had had simply that graphic, it would have been the single most important additional piece of information to them that they did not know, because that flat numbering system was not known by the London Fire Brigade at the time the fire started, and in summary, even at the time when all 6 persons had died, it was still not known by key personnel. And that theme of the importance of knowledge about layout of buildings is one that Mike is going to return to. The London Fire Brigade arrived on the scene within 8 minutes at 16:23, and they set about following their usual practices and procedures with everything apparently going to plan. But, as I've indicated, the layout of the building is not completely straightforward. How unusual it is was a matter of some debate, but what I'll do is just quickly take you through how it worked. You can see that from that diagram, all flats, to some extent, face out onto the west side, but some of them, as you can see with flat 65, have, in effect, 3 windows onto the west side, some of them only 1. The reason is this. That's what a west-facing flat, so half of the flats in the block looked like that. You have a front door on a corridor. You enter into the flat. You've got bedrooms on the ground floor on one side. You then go upstairs where you extend across the full width of the building. So the east-facing flat is the reverse, like that. And if you put the two together, you get, in effect, that. Again, features of the layout that were not known by the fire brigade as at the time when all 6 people had died and could have been potentially very useful. What it means in terms of opportunities to escape from a flat is set out in this graphic. So this is a west-facing flat. If you imagine with a front door onto that central corridor and bedrooms on the west side, there are two ways to get out of the flat on the lower floor, through the front door and also through another escape door. But what's more important is the ability of people to get up onto the upper floor within their flats, because on the upper floor you've got access to escape balconies on both sides of the building. So if you've got a fire which is predominantly on the west side of the building, then even if your bedrooms are on the west side, there is potentially the opportunity to go upstairs and get onto the east balconies. All of these escape routes ultimately lead to a single escape route out of the building itself, namely a single central staircase. Just to illustrate this with photographs, if you walked out of either a kitchen or a lounge and turned left towards the centre of the building, you would be on an escape balcony which looked like this, and at the end of it you would have a door like that, which does not say that it is a fire escape, but it is. It leads to an atrium, and from there to the single central staircase, and from there to safety. And there was mixed evidence from residents about whether they understood and appreciated the purpose of those balconies and where they went, and that they offered fire escapes. This is a photograph that we use quite a bit in the inquest because of the angle that it gives, because arguably somebody looking at it and thinking hard would recognise firstly that it's possible to walk the full length of each of those balconies. So in other words, they're not private balconies for each individual flat, but that one can walk the full length. Secondly, you can see the white door at the end of it, and one might think, what is the purpose of that balcony? Is it there to provide escape routes? And there was a good deal of discussion with incident commanders about whether they ever went through that thought process and appreciated that. And the reality is that they didn't do so until sometime after all 6 people had died. Another point to note about this photograph is the dark green panels. They were all installed as part of a major refurbishment under the Decent Homes programme in 2006-2007, a programme that cost over £2 million and took place just a couple of years or so before this tragic fire. And we'll come back to those panels, which were composite panels with an insulation core, when we look at the chronology of the fire. As I've said, the fire brigade arrived on the scene very quickly, and shortly after the first units arrived, an official fire brigade photographer arrived, and thereon we have very useful photographs of the progress of the fire. So this is an early photograph of the west side of the building, and if I move on 2 minutes, what you can see here is that the floor where the fire started, the 9th floor, is at the bottom of the photograph, and you can see here that the fire has spread 2 floors above, and that those dark green composite panels that I referred to a few moments ago are fully alight on the 11th floor, which was flat 79. Now, the occupant of flat 79 had very dutifully called 999 at 16:21, 6 minutes after the fire started, and this most unfortunate woman remained on the line to the London Fire Brigade until she lost consciousness and died. And the reconstruction evidence about the fire indicated that that panel outside her bedroom window had caught fire at 16:26 hours, and that the bedroom window itself had failed a few moments earlier. And there was a lot of nuanced evidence about this, but in broad terms it would be right to say that one would expect the window to fail first in the event of a fire. And the composite panels added in 2006, 2007 offered no fire resistance. They weren't in fact required to under the regulations, but they were also not class 0. They offered no protection from surface spread of flame, and they burnt through very quickly. We move on now to this photograph, 1649. This is of interest because one can effectively see 4 separate flats within the building on fire. So the one on the 9th floor where it all started, the one above, which we've been looking at, but also fires below on the 7th and 5th floors. Now, the effect of those fires on the firefighting effort was fairly dramatic because the central staircase became smoke-logged and the fire brigade withdrew to the outside the building. What they normally try and do is set up what they call a bridgehead 2 floors below where the fire is, but the effect of smoke logging meant that they had to start their breathing apparatus outside the building altogether. The fire on the 5th floor would in any event have required them to move all the way down to the 3rd floor. So this event, which was variously described as unprecedented or unique, caused a radical change in tactics and was a very major problem in the firefighting and rescue efforts. Having said that, whilst it was certainly highly unusual, whether or not it was unforeseeable was a slightly different question, because it would be wrong to characterize it as the fire moving down the building. What had actually happened was that items of debris had caught fire, fallen under gravity, and then blown through open windows and started new fires. And that was a phenomenon which arguably had been foreseen in various national guidance documents. 1649 was also roughly the time when the occupant of flat 79 lost consciousness and died. The expert evidence was she died between 1650 and 1700, and the other 5 people died in the bathroom of flat 81. Now, they suffered no burns at all. They died purely of smoke inhalation. And I turn then to look at the question of when they died and why they died. They died much later. They died between 1745 and 1805. And this slide seeks to explain why. So in that bathroom in the bottom right corner of the slide, there are effectively 3 different means of smoke spread into the bathroom. One of them is up a ventilation duct because it happened to be connected vertically to one of the flats below that was on fire. But that was the least significant source of smoke. Otherwise, fire spread into flat 81 and smoke came under the bathroom door, and also smoke spread through holes or gaps around pipes which ran from the central corridor into the flat, and there was a lack of fire stopping around those pipes. How did fire get out of flat 79 at all? Well, the primary cause was a failure of what's called boxing in, and I'll demonstrate that with a couple of photographs. So the building itself dated from the very late 1950s. In the 1980s, some new central piping, heating and the like, was installed in the communal areas. So pipes were put up into the ceiling area, and then a suspended ceiling was placed so as to conceal them. The suspended ceiling, as it happens, didn't have any fire partitions in it. Equally significantly, the area where the internal staircases of flats turned through 90 degrees to go up to the top floor had previously jutted out into the central staircase, and this was now boxed in. You can partly see the boxing in that slide. You can see it more clearly here. Now, the evidence was that that boxing in was not original. It was probably introduced in the 1980s or earlier. But it was very important because that boxing in, the reconstruction suggested, allowed fire to burn through it within 3 minutes of it being exposed to flames. And what's significant about this is that fire prevention is premised on the idea of compartmentation, the idea that a fire will be contained within a compartment for a period of time, perhaps 60 minutes, which will be sufficient to allow the fire in that flat to be put out before it spreads and endangers people in other flats. And this vividly illustrates the fact that you only need one, as it were, small problem, one Achilles heel in your materials or your construction or design for the whole concept of compartmentation to fail. What happened in this case was fire got out through this boxing in, which failed within 3 minutes. It then spread into the cavity above the suspended ceiling. Fire raged up and down that. The ceiling eventually came down, and fire also spread into flat 81 through its own boxing in. So those are just the facts in outline, and they will tee up what Mike is going to say later on about some of the lessons to be learned. Then moving to this completely separate topic of recent changes in inquest law, I'm going to look at it under these subheadings. What's now in force, new terminology, time frame for completion of inquests, disclosure, and jury inquests. There won't be a separate slide on new terminology, but I just say at this stage that the Act introduces various new terms, investigations, senior coroners, and the like, which we'll just have to get used to. They'll become second knowledge very simply, and they don't change the law a great deal. It's just a change of terminology. So what's now in force? Well, there are new rules, there are new regulations. They both apply to any inquest not completed before the 25th of July of this year. In addition, commencement order number 15 for the Coroners and Justice Act as a whole means that most but not all sections that deal with coroners came into force or were in force as of the 25th of July. Now, the rules make it clear that any decision made by a coroner before the 25th of July shall stand, so they're not null and void. My own view is that if an inquest is still in the pre-inquest stage, there is no reason why one shouldn't ask for a previous decision to be reviewed and revised at, for example, a subsequent pre-inquest review, or indeed on the first day of the inquest itself, because the rules by now will apply. Time frame for inquests. Now, this is one of the big themes of the Act and of the rules, the aim of completing all investigations within a year of death. Now, I'm interested in how that interlinks with the Memorandum of Understanding between the Coroners Society and the HSE, and how this is going to work in practice in terms of what goes first, inquest or regulatory criminal proceedings. It remains the case that if there's any prosecution for manslaughter, corporate manslaughter, or gross negligence manslaughter, then that has to take precedence. But there was an old Memorandum of Understanding which predated that of September 2011, which broadly emphasised that inquests would take place first, unless there was some particularly unusual reason for the HSE to consider it in the interests of justice to bring their own prosecution first. Then in September 2011, so before these rules, before the emphasis on inquest within a year, there was a new Memorandum of Understanding which gave the HSE much broader discretion to decide for themselves when it was in the interests of justice to commence proceedings before an inquest. And certainly my own experience after that MOU came in was that the HSE were quicker to say, well, this is a case where there's definitely no manslaughter prosecution. We want to get on with it. We're going to bring our prosecution first and ask for the inquest to be adjourned. Now I think we're going to be back very largely to the old position, And I've had a couple of cases where coroners have said, well, I'm listing the inquest, and you, Mr. HSE, will tell me within 6 weeks whether you're bringing criminal proceedings and want me to adjourn, or whether you're going to make no decision or whether you're going to wait. So I think that most coroners will feel duty-bound, quite rightly so, to get inquests listed as soon as they can, and will then leave it to the HSE, try and force their hand to make that decision if they want the criminal prosecution first. But I think we will probably return to the position where the natural order of things is decision on manslaughter, then an inquest, then possibility of criminal regulatory prosecution. Moving on then to disclosure, which is probably the most interesting topic to talk about in the light of the new rules. Principles of disclosure by coroners to interested parties are now governed by the rules. And the rules say that the coroner must, I emphasise must, if requested to do so, disclose any reports provided to him during an investigation and any other document which he considers relevant to the inquest. So on the face of it, a very broad power and also a mandatory requirement. But, however, a coroner may refuse to provide disclosure in accordance with Rule 15 where the request is unreasonable, the document relates to contemplated or commenced criminal proceedings, or the coroner considers the document to be irrelevant. And there are other exceptions as well, but they are the obviously important ones. In addition, a coroner may disclose a redacted version of all or part of a document. So how is this going to work in practice in the regulatory health and safety field that most of us are predominantly interested in? And also, how does this fit with what had previously been agreed between the Coroner's Society and the HSE in that Memorandum of Understanding in September 2011? And I've put on this slide 2 quotations from that MOU. The coroner must act fairly in considering what information to disclose and balance this against any claim of prejudice made by the HSE. And also, blanket disclosure of all material provided by HSE during an ongoing investigation would not be appropriate. So how's this all going to fit together? Well, if I take you back to this slide, which sets out the grounds on which a coroner may refuse disclosure, I think the two probably do fit together fine. I think that it would be open to a coroner to say, for example, well, I'm giving you, documents A, B, C, D, and E, and in the circumstances, your additional request for documents X, Y, and Z is unreasonable because you've got enough information. I would hope that the second exception, documents relating to contemplated criminal proceedings, would be understood narrowly, as it often has been in the past, namely that if the HSE does a report to a coroner saying, we think there have been the following breaches of regulatory law, and the coroner refuses to disclose that, then I'm sure that will remain the same. And I think that's what that bullet point is intended to go to. What I hope it doesn't extend to, and believe it won't and shouldn't, is a widespread refusal to hand over documents simply on the basis that criminal proceedings are contemplated. So my feeling is that there are perhaps 10 or 20% of coroners up and down the land who you could characterise as old school, anti-disclosure, up until now able to say, well, there's nothing in the rules at all about disclosure, so I'm not giving you anything. And I think that 10 or 20% will have to change. But I think that most modern coroners won't have to change their practice in terms of what they disclose. What we will simply have is new language in which to argue these applications, and new language for coroners to use in deciding and explaining what they're going to give and what they're not going to give. However, I think the one difference for proactive interested parties and their solicitors is that the rules provide an opportunity to get disclosure earlier. If one goes back to Rule 13, the coroner must, if requested to do so. And if one looks at Rule 15, there's no exception for a request being made prematurely or early. So I think the sort of disclosure that coroners generally, perhaps 80% of coroners, would give you at some point to give you enough of an opportunity to prepare for an inquest, that kind of package of disclosure will continue to be available, no more or no less, but will and ought to be available earlier if you make the request relying upon Rule 13. Juries, well, the aim of the Act, somewhat watered down, but the aim was very much to reduce the number of jury inquests. And the power to sit with a jury, which remains, has been expressed in a way that is intended to make it slightly less of a knee-jerk reaction to a coroner to summon a jury in any case which it regards as being a little bit unusual or complex. The requirement to sit with a jury in circumstances for continuance or possible recurrence of which is prejudicial to the health or safety of any section of the public was the old 2D requirement, which nobody ever really clearly understood. That is abolished, but these changes will not have a major impact on our practices because juries will remain mandatory in RIDDOR cases, in cases where death was caused by a notifiable accident, poisoning or disease. Just a few other piecemeal changes to draw your attention to before moving on. The practice that coroners have increasingly followed of holding pre-inquest reviews, not something that was previously in the rules at all, is now expressly mentioned in the rules and encouraged. The old Rule 37 on the circumstances in which written evidence was admissible without calling a witness has now been replaced by new Rule 23. It's not an easy rule to interpret, but my understanding is it is intended to make it easier to introduce written evidence. And thirdly, the previous power to write a Rule 43 report or letter has now been slightly upgraded by recharacterising it as a duty to make a report if certain defined circumstances are met. I then move on to the third part of our talk and my final part, which I've called case studies. And I want to use it just to talk about a couple of decisions made in recent inquests that we in Chambers have been involved in and just look at would they be any different now under the new rules. Firstly, in relation to the Lakenal House fire, that inquest sat with a jury, and the reason it sat with a jury was because everybody agreed a jury was mandatory under the rather long and convoluted provision about circumstances and prejudice to health and safety of a section of the public. There was also unanimous agreement that it was not a RIDDOR case, perhaps surprisingly, but the fact is it was a purely residential building. Nobody was working there. There were no offices. There were no caretakers. There was no maintenance work going on at the time. So under the new law, there would be no mandatory requirement for a jury, and the presumption would be no jury unless the coroner felt there was sufficient reason to summon one. And so that's something that might well have been dealt with differently under the new Act. Disclosure. Well, in the Lakenal House fire inquest, the coroner was always extremely keen on providing as full disclosure to all interested parties as early as possible. So I don't think the new rules would have made any difference at all to how disclosure was dealt with. I then turn to expert evidence and the principles governing the content of narrative verdicts. And the first point to make here is that the new Act and the new rules have nothing to say about these. They're silent. These remain complex matters on which there's a good deal of case law, and one will continue to have to turn to the case law. I think the case law on expert evidence is slightly complicated because it tends, perhaps slightly unfairly, to give a tactical advantage to people who quietly go off and get their own expert reports over people who plead with the coroner to get one. And what we had in the Lacknell House case was a lot of interest in the approach by the London Fire Brigade and whether they'd adopted the right tactics on the day and whether they had used all of their powers to get knowledge about the building in advance as fully as they perhaps should have done. So we needed a firefighting expert. Now, firefighting experts are extremely rare, and you're into that kind of area where you can't go to somebody who has a career writing expert reports about how to fight fires because they would be starving. So you have to go and look for somebody who actually knows how to fight fires, but perhaps knows rather less about writing expert reports. And perhaps easier for us to do representing the coroner, assisting her, because we don't mind what the report says, provided the person has integrity and qualifications and experience. And we went to New Zealand to get somebody who we felt was independent of the system in England, but knew quite a lot about it. And he, in due course, gave expert evidence. Now, the family obtained legal aid to get their own expert report. They were open with us as soon as they got legal aid, and they served a report about midway through the inquest and were indicating that they wanted to apply for their expert to give evidence as well. And in due course, what happened, which I think was very sensible, was that they then narrowed their request and said, well, we only want him to give evidence on 5 particular topics. And then they moved it again and said, well, we're going to review the position after the coroner's expert has given evidence and we've questioned him. And ultimately, they abandoned their request to call their own expert because they were satisfied with the credibility of the coroner's expert and also with the way in which he answered the good questions that they had. So that's expert evidence. And then finally, principles governing the content of narrative verdicts. What I want to flag up here, which both Mike and I and Simon have come across in cases, is the tricky question of when a jury would be allowed to express its views on matters that they've heard evidence about, which they're dissatisfied or concerned about, but which realistically could not be said to have been causative of the death. This arose in a long, interesting case Simon did, the inquest regarding Jimmy Mabenga. He was an immigrant who was being deported on a scheduled flight, as is standard practice, and everything looked like it was okay. And then, whilst he was on board the aircraft, but before it had taken off, restraint was used, and very sadly, he suffered cardiac arrest and died on the plane. And the expert evidence was essentially that once he'd gone into cardiac arrest, the opportunity to save his life was very small. And therefore, whatever criticisms people might have wished to make of the first aid he was provided with, realistically, it couldn't be said that better first aid would have probably saved his life. So the court was into the kind of territory flagged up and considered by the Court of Appeal in Lewis, where they said that coroners had a power to invite juries to comment and express conclusions on such matters in a narrative verdict, but didn't have a duty to do so. And the court in that case also talked about it being more desirable to allow juries that remit in cases where they might make factual findings that could be relevant to a Rule 43 letter coroner might want to go on and write. Now, in fact, in Simon's case, he successfully persuaded the coroner not to give the jury the right to discuss non-causative matters in their narrative verdicts, and therefore his client, British Airways, had no adverse comment made about them at all in the narrative verdict. Same issue arose in the Lacanal case, and in my submissions to the coroner were that it was essentially a matter for her, but that I would favour allowing the jury to comment on non-causative matters, but it was entirely up to her. Families predictably sided with that, and all the other interested parties disagreed, and she ruled that they should not comment on non-causative matters in their narrative verdicts. But interestingly, they went on and in fact did comment in quite a nuanced way and quite an open way on non-causative matters, which showed in fact that they were fully capable of coping with the difference between something that was definitely causative and something that was of interest but not causative. And it was of interest to me because I think sometimes one thinks, well, juries are not going to be able to cope with that, and so it's better to restrict their role. And I think that was one of the reasons that was adopted by the coroner in Simon's case. In fact, but as it so happened in the Lacanal case, the jury were up to the task. But it remains a matter which is going to have to be argued in each individual case because of the way the Court of Appeal expressed itself in Lewis. Well, thank you very much. I will now hand over to Mike, who's going to talk about lessons learned from the facts of the Lacanal House fire.
Thank you, James. Yes, I've put up on this first slide a number of different topics, and I'm going to look at some of the lessons to be learned that fall under those different headings. But as we go through, what I suggest that we will see is that there is a considerable degree of overlap between those different areas. They are interrelated, and also we will see that the lessons to be learned from the fire are of wider application, particularly when it comes to the question of fire risk assessment. So the first of the topics that I've put up there is information and advice for residents of the building, and the question of stay put or get out and stay out. And this is really the question of what you ought to do if a fire breaks out in part of the building that you live in. So if you live in a small detached house and you phone 999 and you say there's a fire upstairs, the fire brigade will say to you, well, you should leave the building, don't go back in, and then you'll be safe. If you're in a bigger building, there are essentially two design answers to that problem. The first is to design the building so that everybody in it can be mass evacuated, if necessary. Now, Lacanal wasn't that sort of building, because as you may have spotted in the images we had earlier, it's a very large building. There were 98 flats, lots of people living in it, and only one central staircase. So an attempt to mass evacuate everybody from that building would obviously have brought its own problems. The alternative is to have a building where each compartment will contain the fire for long enough to allow the people in that part of the building to leave if necessary, and for the fire brigade to come along and control the fire and give help to anyone who needs it. What the inquests revealed was that there was a certain degree of inconsistency in the guidance, in the advice that was given to residents between the national guidance and the local guidance that was issued by the London Fire Brigade. And it also highlighted the importance of giving clear advice to the people who live in the building. It was linked to the second point there, challenges in providing fire safety advice to residents. And to give you an idea of the sorts of problems that might exist, you might have residents, for example, for whom English is not their first language. You might have people living in the building, occupying a flat, who are not the official tenant of the flat. So, as James mentioned in passing earlier, we found in the evidence given by some of the former residents that they were not, for example, aware of the purpose of the escape balconies. They didn't know where they led to. They didn't realise that was a way out of the building. And they were not aware of and had not seen some of the fire safety information which had been provided by the London Borough of Southwark, who were the owner of the building and the landlord of all of the tenants who lived there. And the gist of what came out of the inquest was that it highlighted, first of all, the importance of encouraging visits from the fire brigade to come and give advice to people who actually lived in the flats, and also having an effective system for making sure that that information reaches those people, for example, including it in tenancy packs at the start of tenancy, obtaining signatures to show that it's been received, and so on. The last point I put down, premises information, is linked to something called a premises information box, which is essentially a box put in a prominent position on the outside of a building, which contains key information such as plans, an explanation of the layout of the building, important telephone numbers, all of those sorts of things. It isn't mandatory to have a box like that on a residential building or on any other sort of building, but it is something which would have provided the fire brigade in this case with some very important information at an early stage which would have been of real assistance to them. And it's something that owners of buildings may want to consider as a way of making life as easy as possible for the emergency services if there is a need for them to attend the building and act quickly. As for firefighting and search and rescue, it was obvious that in the Lakanal case, because it was a high-rise building, there were particular challenges associated with that. So, for example, the breathing apparatus equipment that the firefighters were using, of course, had a limited capacity. There was a limited quantity of air. And because the firefighters were having to walk up and down 9 flights of stairs before they could do any firefighting, a lot of that capacity was being used up. Similarly, so far as the incident commanders were concerned, there were a large number of people in the building, there were a lot of 999 calls being made, there were a large number of people who potentially might need rescuing. So the fact that it was a high-rise fire brought its own challenges. The second point, though, really was the important one, because the firefighting tactics that were used were standard high-rise firefighting tactics. In other words, the fire brigade proceeded on the assumption to begin with that although there was this fire in flat 65 on the 9th floor, that's where the fire was going to stay for probably half an hour or an hour before it spread into the flats either side or flats above, and as we've seen in this case, exceptionally flats below the floor where the fire started. It was apparent from the investigation and from what happened on the day that the compartmentation had failed, and it had failed very quickly, as James explained earlier. And although the guidance, the high-rise firefighting tactics, did envisage the possibility that compartmentation might fail, what the Lakanal fire did really was to throw into stark relief the seriousness of the consequences of a failure of compartmentation in terms of the speed with which fire and smoke could spread throughout the building and the difficulties that created for the firefighters on the day in terms, for example, of smoke logging and the bridgehead, their base of operations being pushed further down the building. James has also mentioned in passing the point about the fire travelling downwards in the building as a result of burning debris. I won't go over that again, but these were both issues which were addressed afterwards by the London Fire Brigade when they reviewed the guidance for incident commanders dealing with high-rise fires. Staying with the theme of search and rescue and firefighting, brigade control, that is the part of the fire brigade which will receive a 999 call from somebody in a flat. The person will speak to an operator, and what became apparent in the evidence was that the operators who were receiving these calls, based on their experience, which was that the vast majority of people who called 999, who needed to be rescued, would be rescued, they built up an expectation, an assumption, that that person would eventually be rescued. And as a consequence, the 999 calls, for which we had the transcripts in the case, some of them certainly had the tone more of moral support than an effort to ask questions to find out information. And as a result of that, information wasn't obtained, and such information as was obtained wasn't passed on to the firefighters at the fireground. So the best use wasn't made of that opportunity. Similar sort of point about incident command arrangements. During the fire, the incident commander, that is the most senior firefighter directing operations, changed, I think at least on 5 occasions in the early stages of the fire. Some of the incident commanders were only in charge for a matter of minutes, But what that meant was that there was a limited opportunity for those incident commanders to build up a picture of what was happening, to make plans, to decide what resources were needed, and to give orders and receive information. But also that there was a risk of information being lost during handover from one incident commander to another. And that, again, these two are points which were addressed by the London Fire Brigade after the fire in the guidance that was issued. The last three slides look at the question of fire risk assessment. Fire risk assessment really, of course, is the foundation for managing fire safety, because this is the process through which the responsible person can identify fire safety risks and identify the measures to be taken to either reduce those risks or eliminate them altogether. In the case of the Lacknell House fire, the position was that as at the 3rd of July 2009, the day of the fire, there wasn't a fire risk assessment. None had ever been done for a variety of reasons. And the jury in their narrative verdicts described that as a missed opportunity to spot some of the fire safety issues that we've touched upon already. And I suggest in this first slide that there are really three key issues, all of which featured in the Lacknell House inquests. There's the question of who should carry out the fire risk assessment, what should be included in that assessment, and perhaps also importantly, what information does the fire risk assessor have to have before carrying out the assessment in order to put them in the best position to carry out a suitable and sufficient risk assessment. Well, the first question, who should carry out the risk assessment, raises squarely the question of competence. There isn't, as things stand, any qualification for fire risk assessors. There are various organisations that are developing guidance, and it may be in due course that a qualification is developed, but what was clear was that this isn't a one-size-fits-all situation. What is needed is somebody who has sufficient knowledge of the law, sufficient knowledge of building regulations, for example, sufficient knowledge about materials and design principles to understand what they're looking at, but also to spot situations where there is a need for further investigation, somebody who knows what they don't know, if you like. And also the skills and experience that are needed to carry out a suitable and sufficient risk assessment will depend upon the sort of building that you are looking at. So there is a big difference between, say, a one-storey building that has one main entrance and a building as complicated as Lacknell House. There are question marks to do with the scope of fire risk assessments for buildings where part of the buildings are common parts, say the stairs, entrance hallways, and other parts of the buildings are private dwellings. The guidance suggests that it would be appropriate to go into at least a sample of the private dwellings. Why? Well, because there may be features of that building which have a bearing on, for example, compartmentation, which can only be seen from inside a flat. For example, fire sealing around the door, fire seals and smoke seals. What the guidance doesn't explain is how that is to be achieved, because in a large building there may be people who are uncooperative, there may be difficulties in getting access, and the solution to that seems to lie in trying so far as possible to obtain the cooperation of the people who live in the building, but also taking opportunities to combine fire safety inspections with other inspections or opportunities to get into the flat, for example, gas safety inspections, end of tenancy checkout inspections, those sorts of things. Another practical issue is, well, how invasive does the fire risk assessment have to be? Do you, for example, have to take down all of the panels of the suspended ceiling in the corridor to see what's underneath? And the tenor of the expert evidence at the inquests was that, again, it's a question of sampling. What the assessor ought to do is sample, in that case, for example, by taking down a couple of tiles to see what is on the other side, and again, make a judgment about whether there's a need for further investigation. And I would suggest that approach of targeting resources at particularly complicated buildings and of carrying out sampling to identify areas where there is a need for further investigation is likely to be the most cost-effective and appropriate way of carrying out fire risk assessment. This third point is, I would suggest, very important. What information does the risk assessor need? There'll be various types of information that that person will need, for example, about the people who live in the building. If it's sheltered accommodation, there might be people who are disabled, again, people who don't speak English as a first language, perhaps. There'll be information to do with the use that the building is put to, people storing flammable materials, for example, people keeping rubbish on escape balconies, and also questions to do with the design and fabric of the building, properties of the materials that are used, their fire resistance, and also design features of the building, such as the number of escape routes. It's a particular problem in the case of old buildings where there have been refurbishment works, repairs carried out over a number of years, where the design principles that were used at the time the building was built are no longer current, and therefore they're not principles that people might be familiar with and work with on a day-to-day basis. And just to pick out one example, James showed you earlier the composite panels which caught fire very early on and burned through. They were installed during the refurbishment in 2006-2007 in place of panels which contained asbestos. And that change from an asbestos material to a non-asbestos material arguably should have triggered a realization that that might have affected the fire safety of those flats. It might have some bearing on fire safety management. But in order to make that connection, the risk assessor has to know what was in place before. And so in the case of Lacanau, the London Borough of Southwark, in their Rule 43 response, have explained that they now equip all of their fire risk assessors with a pack which contains as much information as possible about the layout of the building, the materials, but also historically what changes have been used and the significance of particular aspects of the building and the materials used. The last couple of points are not to do with fire risk assessment itself, but are, of course, an important part of the context in which the fire risk assessment is done. There's no point in having an assessment document which is out of date. It's true of risk assessments in other contexts, particularly in the case of fire risk assessments, because things can change without you knowing about them. Tenants, for example, might make an alteration inside their flat. In flat 79, the flat above the fire flat, one of the walls had been taken out inside the flat, and that allowed smoke to travel faster and more easily than it could have done otherwise. So the fire risk assessment has to be kept up to date, and there may be triggers which will prompt a review, for example, a refurbishment programme, but otherwise there is a need to prioritise reviews so that they reflect the degree of risk and the complexity of the building. So in the case of a more complicated building, the frequency of review arguably should be more frequent than in the case of a simpler building. Ensuring appropriate engagement with building control, I've included because a feature of the Lacanau case was that the work done in 2006-2007 had never been run past Southwark's building control department. So nobody in building control had ever considered the fire safety implications of those refurbishment works. And that situation had come about essentially due to confusion about whose job it was to deal with fire safety. Was it the designer, which was an internal department at Southwark? Was it the main contractor's responsibility? Was it the subcontractor's responsibility? It wasn't clear, and it slipped through the cracks. Nobody did it. And that raises perhaps a more general question of the need to think about when it's appropriate to engage outside help, outside expert help. The last point, again, is something which came out of Southwark's Rule 43 response, really thinking outside the box. How can you create other opportunities to spot fire risk problems? And part of their response explained that they have now trained the staff who carry out and manage their major works, their maintenance staff, in fire safety, so that, again, they can spot potential problems and refer it to their fire safety team if there's a need to take anything further. So really it's a case of giving yourselves as many chances as possible to spot those sorts of issues and address them. Well, thank you very much for listening. I'll hand over now to Julia for her talk on sentencing.